Bullhorn Betty versus Queen Bee, Civil Action Number 2023-LA16. Response to defendant's motion to dismiss Section 2-615 comes now. Plaintiff BHB, acting as pro se in the action, files the response to defendant's motion to dismiss Section 2-615 for grounds stated as follows. Background. On or about October the 18th of 2023, BHB served Queen Bee with an amended complaint alleging defamation, tortious interference with prospective economic advantage, intentional infliction of emotional distress, civil conspiracy, and concert of action negligence of unjust enrichment. Queen Bee caused damages to BHB for over a year. BHB did nothing to justify this outrageous and detrimental campaign of bullying, stalking, harassing, and other damages that Queen Bee knowingly inflicted on BHB for no other purpose than to cause damage to BHB for monetary and other gains and or benefits realized by QB. BHB has alleged, among other issues, that Queen Bee has conspired and communicated with others through private chats such as Discord and other similar sites to elicit help with Queen Bee's campaign of harassment, cyberstalking, bullying, and intimidation to receive financial compensation to damage BHB personally, professionally, financially, and to remove BHB from the YouTube platform. On or about November the 2nd of 2023, defendant Queen Bee filed a motion to dismiss the amended complaint citing conflicting law, which is at issue in this matter. Response to introduction. Queen Bee has filed this ridiculous motion to dismiss, basically stating BHB is only doing this to quell criticism. This could not be further from the truth. Nothing Queen Bee has done has been criticism. Most of Queen Bee's conduct is criminal, not civil. However, there is no remedy in the criminal law that will assist BHB in a successful prosecution of Queen Bee because Queen Bee resides in a different state. And therefore, unless the Federal Bureau of Investigation investigates this case, nothing will be done with respect to criminal charges due to jurisdictional matters. Queen Bee has violated Florida, Illinois, and federal criminal laws. Queen Bee has violated Florida, Illinois, and federal civil laws. One such demand is for a criminal investigation into Queen Bee's conduct in the state of Illinois. It is highly unlikely that this court or the opposing counsel really believes this is over criticism. Attorney has requested this court for sanctions and or attorney fees for challenging his reputation. Yet attorney expects BHB to continue to take Queen Bee's violating federal, Illinois, and Florida criminal and civil codes and continues to do so as this matter is being litigated. Queen Bee is completely obsessed with BHB to the point Queen Bee will not stop without an order of this court to do so until Queen Bee creates another life-threatening situation where BHB is injured with bodily injury and becomes deceased. BHB's well-being is in jeopardy, and I pray this court takes Queen Bee's actions seriously. BHB fears for her personal safety and life. Queen Bee has recently created yet another situation where Queen Bee called for her audience or mentioned someone should call the cops on BHB during her visit to Tennessee. That is all it takes to incite Queen Bee's audience. Queen Bee constantly is working with other creators to assist her and recently named them in a recent live broadcast on Queen Bee's channel. Queen Bee openly admitted with not only working with them, but specifically speaking with them about BHB and to coordinate behind the scenes for the sole purpose of damaging BHB and to keep BHB in a constant state of fear to prevent BHB from moving freely throughout the United States for business purposes. Queen Bee has and continues to create dangerous situations because Queen Bee and her cohorts constantly keep BHB under surveillance and creates dangerous situations for BHB. Queen Bee rewards those that attack BHB, call law enforcement on BHB, and keep Queen Bee up to date with the movements of BHB. These are all criminal acts, not civil. However, as stated before, BHB has no other remedy at law than a civil action, which BHB has properly engaged in currently. Queen Bee conspires once again with her audience and content creators to have BHB arrested for a DUI, although BHB did not consume one alcoholic beverage during the entire time BHB was in Tennessee. Queen Bee audience called into Sumner County Sheriff's in Tennessee, stating BHB was swerving all over the road. Queen Bee and her friends did this for their own content to make money from it because they knew I was live and they would capture the law enforcement engagement for their future shows, which Queen Bee and Queen Bee cohort did just that. They are literally using law enforcement and the 911 system for content for their shows. This is disgusting and appalling and goes beyond the bounds of normal decency and needs to stop. Queen Bee once again reached out to the persons of interest in the disappearance of an autistic 15-year-old boy, which resulted in BHB being followed and stalked for over 30 minutes by a member of that family. This put BHB's life in jeopardy again. BHB has the dispatch calls, Queen Bee making comments about the calling law enforcement publicly on Queen Bee's channel, and one of Queen Bee's unnamed and unknown audience members are heard stating she is the one that called the 911 system, as Queen Bee is thanking her for doing so. This creates a situation where Queen Bee's audience feels emboldened to continue this harassment, unlawful surveillance that is only designed to keep BHB in a constant state of fear in performing BHB's job functions. Moreover, on or about June 26, 2024, Queen Bee had blank, aka Illuminati, from blank on Queen Bee's panel publicly threaten bodily injury to BHB if BHB comes to the area. This is a live broadcast. This was an act of intimidation towards BHB. URL listed. This has been viewed 8,550 third parties. The title of this live is Tragedy Pimps, Temper Tantrums, and a Clown Straight from Skid Row. Sebastian's case turns into a circus. At about the 2-hour, 25-minute, and 24-second mark, Illuminati goes on Queen Bee's panel, where they are once again discussing BHB. Mind you, there are literally thousands of true crime content creators on this platform, about 150 content creators that do exactly what I do across the country. However, Queen Bee focuses only on BHB. At the above time, Queen Bee is falsely stating to Queen Bee's audience that BHB at 3 o'clock in the morning went to a home, Proudfoot's home, where a crime was committed, stating BHB is harassing the people in this particular home. Harassment is a crime. I never went to the Proudfoot's home. I drove by it. That's it. This is exactly how Queen Bee incited Queen Bee's audience to attack BHB with insightful, untrue statements about alleged criminal activity. While by itself may be constructive criticism, but the action of inciting Queen Bee's audience and then having Illuminati on her panel threatening BHB pushes Queen Bee's audience over the edge. And then Queen Bee's crew start keeping BHB and BHB's movements under surveillance, even when BHB is not live or when BHB is trying to keep a low profile. Queen Bee believes she is entitled to stalk BHB and use her audience to do it. Queen Bee has failed to use licensed private investigator to surveil BHB, as the law requires. Around the 2-hour, 26-minute mark, they again start discussing that BHB trespassed, a criminal act, onto someone's property for posting a flyer of a missing boy on a utility pole, which incited Queen Bee's audience and the content creator Queen Bee elicits help from to encourage people to monitor BHB and call local law enforcement. Queen Bee and Queen Bee's cohorts encourage people to call into law enforcement even when BHB has committed no crimes or violations. These actions keep BHB under fear of arrest when BHB has committed no crimes. This is going on while we are in active litigation. Queen Bee is a thug, a bully, a criminal actively breaking the laws in Queen Bee's own state. BHB spoke to law enforcement officers that pulled BHB over, and he stated people from YouTube were calling the sheriff's office and reported BHB swerving, among other things. Not one call came from a resident in Tennessee. BHB called Queen Bee and Queen Bee's friends out on a live after the information the deputy sheriff provided, and then Queen Bee is professing BHB did not have the cops called on BHB, which Queen Bee knew was false because Queen Bee told her audience previously someone needs to call the law on this bee. Well, it is funny. No matter where BHB goes, BHB is approached by law enforcement from a callers from YouTube. When those people are identified, they are connected to Queen Bee. Why is all the damage BHB is being subject to always lead back to Queen Bee? But for Queen Bee, BHB would not have had any contact with law enforcement. This will be supported by public records received by Summer County Sheriff's Office. Queen Bee states that Queen Bee literally timed BHB and how long BHB stayed in a parking spot in a public area. This is highly disturbing. Who does that? That is cyberstalking and a criminal act. This is stated at the 2-hour, 30-minute, 30-second mark of this video. This video is a great example of what they are doing to BHB and how BHB is under constant surveillance when BHB is online or offline. At the 2-hour, 45-minute, 16-second mark, you will see why this was orchestrated by Queen Bee for Queen Bee's content and for what is referred to as clicks and views. Queen Bee has been doing this for content, and it is highly disturbing. Queen Bee and Queen Bee's cohorts sure capitalized greatly by BHB being pulled over. At 2 hours, 47 minutes, and 2 seconds, they are saying BHB received a warning from law enforcement, which BHB maintains BHB did not. But it is all about inciting the audience about BHB's criminal activity that Queen Bee has manufactured for content. 2 hours, 48 minutes, Queen Bee and Queen Bee's panel states BHB stalked a person, a criminal act for parking a public parking lot where BHB was about to eat dinner. It is well established across this county that there are county easements and setbacks on every property built, which does not constitute trespassing to post a flyer on a utility pole. These statements were designed to incite Queen Bee's audience with yet again falsehoods, knowing one of Queen Bee's audience members would act, because they always do. At this point, Queen Bee is adding more claims to BHB's already growing complaint. BHB is entitled to amend the complaint to add these new claims. At the 3-hour, 12-minute mark, Queen Bee lists all the people Queen Bee has been working with and conspiring with. At the 3-hour, 15-minute mark, Queen Bee and Queen Bee's panel are discussing how terrified BHB has been while in the state of Tennessee and publicly stating they want to shake the hand of whoever called law enforcement on BHB. Queen Bee is literally encouraging this behavior, and Queen Bee's audience is the one doing all of this at Queen Bee's request. Queen Bee is the puppet master, the OG, Escobar, and the top dog of this campaign. At the 3-hour, 19-minute, and 36-second mark, Queen Bee and Cluminati start working themselves up and then start hurling threats towards BHB. Queen Bee has removed Cluminati's threats that if BHB shows back up to Tennessee, BHB will be dealt with in an attempt to conceal this behavior from the court. Queen Bee laughed and encouraged this behavior. BHB personally listened to the threats before they were removed. Queen Bee is obsessed with BHB and BHB's demise and will stop at nothing to see this through. This is the only way to explain why Queen Bee will not stop. Queen Bee is a danger in the community of Knox County and a danger to the people online, including BHB. BHB called law enforcement twice during this trip over Queen Bee and Cluminati's shenanigans. This is absolute disruption of BHB's business and daily life. This has persisted for over 2 years. Every case BHB is involved with, Queen Bee causes problems for BHB. But for Queen Bee's conduct, BHB would not be dealing with any of this. BHB sent a cease and desist letter to Queen Bee's counsel, attorney, where he basically told BHB not to bother him. Attached is Exhibit A. In this letter, BHB expresses BHB's concern about BHB's personal safety, including death. And attorney response is disgusting and sanctionable. Attorney conduct may rise to inclusion into this lawsuit no different that Stephen Bertolino in the Gabby Petito case, which Bertolino settled with the family. Stephen Bertolino made statements on behalf of his client, Christopher and Roberta Laundrie, when he issued a statement expressing hope that Petito would be found. BHB is in fear for BHB's safety, and Mr. Queen Bee states he's not his client's babysitter. It goes beyond the boundaries of decency and is an outrageous statement which initially caused BHB additional infliction of emotional distress. These are ongoing torts and damages BHB has raised since the onset of this action, and this is continuing conduct creating additional claims. Illinois law prevents BHB from reaching out to his client directly. All communication must go through Mr. Attorney. His response is sanctionable, among other remedies at BHB's disposal. This is a continuation of the conduct and grievance laid out before this court, and therefore a part of this lawsuit, and therefore he is the person that I must contact. Opposing counsel cannot control his client. Therefore, The courts must, and court intervention is be needed, preserving BHB's right and ultimate safety of BHB. Queen Bee wants BHB arrested, be assaulted, or worse. Queen Bee is using Queen Bee's platform in hopes of someone hurting BHB with bodily harm. Otherwise, why is Queen Bee continuing this behavior even after the conducted ended and litigation began? There is no other reason for Queen Bee's current conduct, which has not stopped for over 2 years at this point, and feel this court is not understanding the gravity of the situation. If this conduct continues, BHB might not be here to see this action through. BHB is in constant fear for BHB's safety. Queen Bee is a danger to BHB. Illuminati went out of her way to publicly state the private location BHB was staying while visiting Tennessee, even after BHB relocated multiple times. This was a concerted action between Illuminati and Queen Bee. This put BHB in danger of property damage and bodily harm. Does this court find it odd that Queen Bee seems to be involved each and every time BHB is damaged or harmed? It is the belief of BHB that Queen Bee is hopeful one of her subscribers will be so enraged they do the dirty deeds, which they have done in the past on Queen Bee's behalf, which is what BHB has alleged since the onset of this litigation. Prior to this, Queen Bee and Queen Bee's right hand, Burnt Toast, publicly went after one of my channel moderators and attacked her shirt business to cause financial harm to a team member. This is an act of intimidation. BHB sent a cease and desist letter to Queen Bee's attorney for that, which BHB did not receive a response. Mr. Lawyer conduct has been atrocious and bodes more in assisting Queen Bee in facilitating and shielding Queen Bee's conduct, so Queen Bee can continue Queen Bee's terror upon BHB as opposed to Queen Bee's counsel. His client is out of control, and court intervention is needed before BHB is hurt physically or worse. This court has a duty to BHB, and what BHB has had to deal with. There are no other remedies at BHB's disposal except the civil action route. BHB has prima facie case. BHB is before this court with clean hands and begging for help. BHB's life matters, and no one appears to be trying to protect BHB but BHB. This is a very dangerous game Queen Bee is playing with BHB's life. It is just that serious. Opposing counsel is aware of these situations and does not care whether BHB is hurt or removed permanently. He only cares about winning this case at all costs. Queen Bee is engaging in intimidation tactics towards BHB since the onset of and directly connected to this lawsuit. This is just another delay tactic used by the defense to slow justice for BHB and to allow Queen Bee to continue Queen Bee's campaign of terror for compensation with the full support of her counsel, which is clearly displayed in the email chain attached here too. Relevant procedural history. BHB's statement is simple. Queen Bee's recount of this issue are flawed and inconsistent with the actual facts that transpired in the prior complaint. BHB has substantially altered BHB's original complaint to the second amended complaint in accordance with the guidance of this court and has a strong prima facie case that this court is unable to deny exists. Response to governing law. BHB agrees there is a process and procedure for the motion to dismiss based upon legal deficiencies, but here Queen Bee is alleging affirmative defenses and not necessarily legal deficiencies. Moreover, Queen Bee argues evidentiary matters coached as legal deficiencies. Queen Bee has targeted BHB before October 2022, and this conduct still persists to this day. Queen Bee will not stop until forced to by this court, or the penalties are so great it deters Queen Bee from continuing this conduct. This is proven by Queen Bee's conduct even after this action has been initiated. There are governing laws in Illinois that state BHB may sue Queen Bee for these torts and or damages, and that is exactly what BHB is utilizing those laws to properly do. BHB maintains the second amended complaint. SAC is and correctly outlines causes of action on each of the counts asserted, including the harassment count. Illinois law states if there is no other remedy at law, BHB may bring action civilly related to the harassment count. BHB has no other remedy at law because BHB is not in a domestic relationship with Queen Bee, nor will any protective order under the stalking law prevent the online harassment. A protective order has been requested through these proceedings, but even if granted, would only protect BHB while in the state of Illinois. Florida will not extradite Queen Bee to Florida for the crime of harassment, and therefore BHB has no other remedy at law other than civil. Governing law over this case supports BHB's position and does not diminish them. The case law cited is correct, but only supports Queen Bee's position in part, related to Section 88 and possibly Count 2. Harassment, all others are well pleaded and can be answered, if not for these delay tactics by Queen Bee. Queen Bee has listed affirmative defenses and evidentiary matters as standing for the rest of the counts and does not survive the motion to dismiss. Under the traditional rule, when considering a Fed R Civ P 12b6 motion to dismiss, the district court must constitute the complaint in a light most favorable to the plaintiff, accept all of the factual allegations as true, and determine whether the plaintiff undoubtedly can prove no set of facts in support of his claims that would entitle him to relief. Response to Queen Bee's argument. 1. BHB claim of defamation per se is not well pleaded, as there are no specific statements alleged, and even the characterizations of alleged statements are plainly non-actionable. Obviously, the sexual intercourse statements are a huge no-no, which were accompanied by an animated video of BHB allegedly in bed with blank, aka Dolly Vision. When it comes to defamation per se, and BHB understands why Queen Bee would express BHB does not have standing to bring such a claim, but that does not make it so. In accordance with Illinois law, to prove defamation against a defendant, a plaintiff must prove 4 elements in the defamation case. First, they must prove that the defendant made a false statement about the plaintiff. Then they must prove that the defendant relayed the false statement to a third party. Libel and slander are different types of defamation. Libel is written, false statements about another person, and slander is a false oral statement about another person. Illinois considers libel and slander the same when it comes to defamation lawsuits. A defamation case can prove either libel or slander. The next step in the defamation case is proving fault by the defendant. The defendant must have displayed at least negligent fault for the plaintiff to prove defamation. Illinois court applies a reasonable grounds standard of negligence in defamation cases. The defendant must either know the statement was false or believe it to be true, but lack reasonable grounds for that belief. If the statement is not a defamation per se statement, the plaintiff must show the court that the defendant's statement caused harm to them or their business. This harm can be reputational or financial. In order to state a defamation claim, plaintiff must plead facts demonstrating that the defendant made a false statement about plaintiff, that the defendant made an unprivileged publication of the statement to a third party, and that the publication caused damages to plaintiff. Stone v. Paddock Publications, Inc., 2011, Ill at 1st, 093386. A statement is defamatory if it harms an individual's reputation by lowering the individual in the eyes of the community, or if it deters the community from associating with the individual. Emphasis added. ID. Statements can be considered defamation per se or defamation per quad. Collegas v. Heftel Broadcasting Corp. 154 Ill 2D 110 1992. A statement of defamation per se if its defamatory character is obvious and apparent on its face and injury to the plaintiff's reputation can be presumed. Owen v. Carr 113 Ill 2D 273 277 1986. In a defamation per quad action, damage to the plaintiff's reputation is not presumed. Rather, the plaintiff must plead and prove special damages to recover. Bryson v. News America Publications, Incorporated, 174 Ill 2D 77103 1996. Illinois recognizes 5 categories of statement that are defamatory per se. 1. Words imputing the commission of a criminal offense. 2. Words imputing an infection with a loathsome communicable disease. 3. Words imputing an individual's inability to perform his employment duties or a lack of integrity in performing those duties. 4. Words imputing a lack of ability in an individual's profession or prejudicing an individual in his or her profession. And 5. Words imputing an individual's engagement in fornication or adultery. Stone, 2011, Ill at 1st, 093386. Because a claim of defamation per se relieves plaintiff of the obligation to prove actual damages, it must be pleaded with a heightened level of precision and particularity. BHB contests Queen Bee had full knowledge of the consequences Queen Bee's actions would have on BHB. Queen Bee had every intention of damaging BHB by knowingly peddling false statements and information about BHB and eliciting others to also peddle the same false information. Queen Bee's only focus was damaging BHB by defamation in an effort to embarrass BHB and to remove BHB off the YouTube platform or enrage Queen Bee's audience, so much so that Queen Bee's audience would then harass BHB by large numbers on a daily basis. Here, Queen Bee intentionally, willfully, and maliciously BHB disseminated false and misleading statements and/or information about BHB to Queen Bee's audience and other individuals, a third party, by making false claims and statements about BHB on QB's live stream broadcast to thousands of people, and posting written articles and other defaming content in Queen Bee's community tab, which is in print format, to thousands of people with malicious afterthought and with reckless disregard for the law or the extreme harm QB's conduct has had on BHB financially, personally, and professionally. The extensive nature of this claim is outlined in the SAC. Since the initiation of this action against QB, some of those videos are no longer in the public domain. Under the community tab section, Queen Bee has reshared and or reposted other defaming and false content about BHB. QB would repost knowingly false videos, live streams, broadcasts, and or posts from other channels QB elicited for help. The constant defaming content has had negative consequences and damages to BHB. QB did not intend to be factual. QB's only mission was to damage and or destroy BHB in the eyes of the public and YouTube community at all costs for financial gain and the potential notoriety for removing BHB from the YouTube platform. If Queen Bee had been successful, Queen Bee has made so many publicly defaming, untrue statements about BHB over the preceding 12 months that there are too many to count. The amount is somewhere at approximately 1,000 statements or more if BHB had to estimate. It is overwhelming, extensive, outrageous, egregious, and goes beyond the bounds of normal decency. Queen Bee has declared publicly Queen Bee is aware the internet is forever, yet intentionally, willfully, maliciously, and with afterthought defamed BHB for profit, notoriety, and attention. QB failed to demonstrate any duty of care or moral turpitude. Queen Bee had to have an expectation that Queen Bee's malicious and outrageous conduct would be and continues to be damaging to BHB's past, present, and into perpetuity. BHB maintains BHB had never spoken to or about Queen Bee in any capacity prior to this targeted attack, leaving BHB confused as to why BHB was the target of such a defaming campaign and attack designed to ruin BHB financially, personally, and professionally. As previously stated in Bryson versus News America Publications, Inc., 174, Ill. 2D 77103, 1996, Section 29, Illinois recognizes 5 categories of statements that are defamatory per se. 1. Words imputing the commission of a criminal offense. 2. Words imputing an infection with a loathsome communicable disease. 3. Words imputing an individual's ability to perform his employment duties or a lack of integrity in performing those duties. 4. Words imputing a lack of ability in an individual's profession or prejudicing an individual in his or her profession. And 5. Words imputing an individual's engagement in fornication or adultery. Stone, 2011, Ill. App. 1st, 093386, Section 25. Because a claim of defamation per se relieves plaintiff of the obligation to prove actual damages, it must be pleaded with a heightened level of precision and particularity. Queen Bee has defamed BHB with 4 out of the 5 categories listed. Queen Bee imputing BHB's engagement in fornication or adultery. According to Stone, BHB does not have to prove damages. QB damaged BHB. Those damages are absolute and supported by case law. Paragraph 88, Scrivener's error, and should have been removed. With that said, BHB has listed with specificity exactly what false statement Queen Bee relayed to third parties on multiple occasions, and those are found in Facts Common to All Counts section. The statements listed are false, and BHB was damaged. Queen Bee's only goal is for BHB to have proffer all financials so Queen Bee and her team can plaster them all over the internet for content and money at the expense of BHB. The statements were false. Moreover, this court is legally sufficient. Queen Bee made statements that were untrue, and those untrue statements were communicated to third parties, caused damage to BHB, and were known to cause damage to BHB on its face. Queen Bee would love this court to believe that somehow Queen Bee had knowledge of BHB's sexual exploits, which Queen Bee does not. Any statement made about any sexual activity would be false and or unknown to a person that has no knowledge of BHB or even knows BHB. Queen Bee does not know BHB, and BHB would never communicate any personal information of this nature to anyone BHB has no knowledge of. Any statements QB makes related to who BHB has dated or otherwise would be false because Queen Bee has no firsthand knowledge, does not know BHB personally, does not live near BHB, nor has Queen Bee so much as held a conversation with BHB. BHB has no knowledge of who Queen Bee is or why Queen Bee is attacking BHB, BHB's reputation, finances, or trying to have BHB physically injured or worse. Queen Bee had no business having discussions such as this when Queen Bee has never even spoken to BHB and BHB does not know Queen Bee. Queen Bee intended to cause damage to BHB and Queen Bee did cause BHB damage. BHB did not encourage any of this conduct. Somehow BHB precisely stating the facts is no longer welcome according to opposing counsel, and the malarkey provided as Queen Bee's unfounded argument about legal sufficiencies specifically related to the sexual relations allegation. The illusion that this court is somehow ignorant to the damage Queen Bee has caused is a little offensive. There are no affirmative defenses that can be raised because Queen Bee has none. Just delay tactics. A. BHB assertion that she did not have sex with Dolly Vision in a car. SAC PP 24-26. Queen Bee's statements were listed. Those statements are false and those statements caused damage. Queen Bee stated with impunity that BHB had sex with Dolly Vision in a car and prepared animated depictions of the same. These statements are false and designed to injure and damage BHB. These statements were communicated with third parties. BHB has a cause of action. In fact, these statements are known to cause damage on their face. So much so, Illinois courts have recognized this and removed the need to prove damage because they are meant to cause damage. Queen Bee has willfully, maliciously, and thoughtfully caused BHB great damage. Queen Bee standing at an attempt to dismiss this action is not well taken. Queen Bee is using word salad. It has been well established that Queen Bee made these false statements online and on Queen Bee's own YouTube channels, Queen Bee and The Hive. Queen Bee's audience is unknown, but there is proof of the number of third parties those statements were communicated to on YouTube by way of the viewer count of each video. The audience members and third parties are unknown to QB, and therefore they are unknown to BHB. It is overly burdensome to request BHB to state every single 100,000 plus third parties by name that Queen Bee communicated these false statements to. It is published on Queen Bee's YouTube channel in video, live stream, and publication formats available to the public, which has been well established in BHB's SAC. This is the who, what, when, where, and how. This clearly defined. Who, Queen Bee. What, made false statements about having sexual relations with Dolly Vision. When, on or about October 2022. Where, online and offline. And how, videos, live streams, and publications. This has been well established. Queen Bee made false statements about BHB's sexual relations. Those statements were false. Those statements were communicated to thousands of third parties. Those statements caused damage to BHB on its face. The who, what, when, where, and how is clearly defined and outlined. BHB realizes that the defense would like to say this and that about allegations outlined in the SAC as mere opinions and innocent construction issues. Queen Bee made these statements willfully with the full knowledge of the damage they would have caused and had reckless disregard to the damage to BHB and Dolly Vision. Queen Bee wanted the financial windfall that came from making these claims and have profited greatly off making them and failing to retract those statements even after Queen Bee knew they were false. Queen Bee was put on notice to remove all defaming content by the cease and desist letter Queen Bee initially avoided receiving, but Queen Bee did receive the email and failed to act. However, just because the defense alleges BHB has no standing does not make it so. BHB admittedly denies this position as Queen Bee made this statement and many other statements alleged in the SAC as statements of fact and not opinion, as Queen Bee erroneously and falsely claimed and implied to be therein. Queen Bee initially stated BHB had sexual relations with a person. That statement was untrue, nor would Queen Bee have any knowledge of such a fact. And even if true, Queen Bee would have no knowledge of any of it, nor should it have been discussed openly when no one speaking about these alleged facts would have any knowledge of the same. Queen Bee initially caused BHB damage, and Illinois law protects BHB from these baseless claims. BHB assertion she has had few interactions with law enforcement than generally understood. SAC PP 26-27. The defense cites case law that assists BHB, not Queen Bee. Here, Queen Bee once again argues innocent construction. I doubt this court is buying into this Mother Teresa act being displayed by Queen Bee in these pleadings. Queen Bee was eager to terminate BHB from the YouTube platform by imputing BHB's character and reputation in the eyes of the public. Queen Bee's commentary was false and caused BHB damage. Illinois law provide 5 categories to claim defamation per se. Queen Bee's conduct has allowed BHB to claim 4 out of the 5 categories allowed under this cause of action. Queen Bee would like the court to believe that Queen Bee did not make these as a statement of fact, which Queen Bee did. Those erroneous statements of fact damaged BHB. Queen Bee believes Queen Bee case say whatever Queen Bee wants for profit despite the damage it causes. Queen Bee's intent was to damage BHB. Queen Bee has stated under the fact common to all counts section that BHB harasses families. Harassment is a crime. Queen Bee's statements were false and caused damage to BHB. Queen Bee openly stated BHB is actively committing crimes and that law enforcement needs to be immediately called. Queen Bee and or subscribers of Queen Bee's channel called law enforcement over 50 times to report BHB when BHB was not breaking the law. That is not only stating BHB is a criminal, that is action to have BHB arrested and or handcuffed. That is not an option or innocent construction. Those statements were statements of fact, and those untrue statements not only damaged BHB, but Queen Bee actively tried to have BHB thrown in jail and continues to try to have BHB thrown in jail as soon as June 2024 while BHB was in Tennessee, which Queen Bee publicly encouraged Queen Bee's audience to do so related to Queen Bee's most recent attack against BHB. This is intimidation. Queen Bee further validated or use of convincing language to Queen Bee's audience to solidify BHB as a criminal, including not limited to passing around a binder depicting BHB's criminal record, and stated to Queen Bee's audience BHB has been arrested 42 while displaying a court docket of all civil cases, criminal cases, and citations on it, creating the 42 items listed. This was knowingly false because Queen Bee read the court docket and knew those were not arrests, but continuously stated BHB was arrested 42 times. This was intentional and deliberate. Queen Bee knowingly spread false information about alleged criminal conduct of BHB, which under Illinois law provides a cause of action for those statements under defamation per se. These statements were knowingly false. They were communicated to third parties, and BHB suffered damages. QB states BHB failed to specifically state the criminal activity, but that is untrue. BHB states precisely who, what, when, where, and how, adding demonic activity, breaking the law, and BHB should be in jail for all these crimes committed with was solidifying the crimes listed, and the fact Queen Bee made these as statements of fact, moreover, was actively trying to throw BHB in jail. BHB has pleaded ultimate fact, has a prima facie case, and Queen Bee damaged BHB with the knowingly false information. Queen Bee is initially splitting hair to confuse the court of the actual issues. Queen Bee made these statements with the sole purpose of damaging BHB, which Queen Bee did. Under Illinois law, state BHB has a cause of action for defamation per se for this category. C. BHB being good at her job. SAC 27-29. Queen Bee continually states BHB's SAC is characterization, however, fails to review the facts common to all counts, which clearly defines with specificity the many statements Queen Bee has made to condone BHB with respect to BHB's career. These false statements not only impugn BHB's character as incompetent at BHB's career, but also lowering BHB in the eyes of the public. According to Illinois case law, this created a cause of action for defamation per se. Queen Bee willingly, intentionally, and with malice committed to third parties BHB's inability to perform BHB's job, words imputing a lack of ability in an individual's profession or prejudicing an individual in his or her profession. BHB has stated the many statements Queen Bee made clearly and with specificity, so much so Queen Bee could answer, but chose to delay these proceedings to avoid accountability to Queen Bee's actions. This is not well taken. These were statements of fact, not opinions. Further, where these statements were stated as opinions or facts would require an evidentiary hearing on that matter. The SAC would survive because most of the issues raised by Queen Bee would require an evidentiary hearing, therefore not subject to a motion to dismiss based upon legal sufficiency. Queen Bee states anyone can be anyone online, such as X, formerly known as Twitter. However, BHB is not stating Joe Blow made these statements. BHB has alleged Queen Bee made these statements. The statements were published to the public from Queen Bee's own channel, and therefore who made these statements are not up for debate. Queen Bee made these statements for the sole purpose to damage BHB. Queen Bee's actions, then and now, have caused damage to BHB. Further, Queen Bee states it is the opinion of Queen Bee that BHB is exploiting a case for profit. Exploiting is a legally defined term describing criminal activity. Black Law Dictionary defines defines exploiting, exploitation, as the act of taking advantage of something, the act of taking unjust advantage of another for one's own benefit. Exploit. Clearly, this is not just innocent construction or opinion. It was decisively language used to injure BHB with no justification in doing so. Queen Bee's actions and language were calculated to cause damage to BHB, and those false statements made to third parties that are at issue damaged BHB, and according to Illinois law, those statements are defamation per se and not defamation per quat, which Queen Bee is hoping this court buys that position, which it should not. BHB agrees that Queen Bee has a First Amendment right to speak. However, that is not what Queen Bee is doing. Queen Bee is maliciously trying to harm BHB beyond repair. Queen Bee has damaged BHB. Queen Bee has threatened BHB. Queen Bee has used Queen Bee's audience to attack BHB and then rewards them with recognition and applause when they cause BHB damage, perpetuating the cycle to continue. Queen Bee is a threat to BHB. BHB fears for BHB's safety because of Queen Bee, and Queen Bee continues these unprovoked actions against BHB. Queen Bee states BHB's press badge is fake. Queen Bee is engaging in word salad. Many people possess the press badge by organizations to identify them as press. It is real and therefore a false statement to impute BHB's business as not legitimate and BHB incompetent, which falls under defamation per se. Queen Bee willfully and maliciously targeted BHB. Queen Bee made untruth statements as statements of fact to impute BHB credibility at BHB's job. Accordingly, BHB has a cause of action for defamation per se. These false statements were made to third parties and damaged BHB. Moreover, provides a path forward for defamation per se under this category. Queen Bee statements were words imputing BHB's inability to perform BHB's business, job, duties, and or a lack of integrity in performing those duties, as well as words imputing a lack of ability in an individual's profession or prejudicing an individual in his or her profession. Queen Bee made these statements as facts to third parties and not innocent construction or covered under First Amendment argument. Queen Bee's intent was to damage BHB, and BHB was damaged as a result. Accordingly, under Illinois law, these statements are known to cause damage on their face. So anything over and above that, whether Queen Bee is stating that or not, then an evidentiary hearing would need to be had, because the law clearly defines that they are not only defamation per se, but are known to cause damage to a person on their face of the falsehood. 2. There is no cause of action for harassment. BHB contests that there is no adequate law or adequate remedy at law for BHB. 3. BHB has not pleaded that she could not enter into a contract with Google/YouTube and pleads herself out of the court by explaining she does in fact have one, showing there was not tortious interference with prospective economic advantage. Courts and litigants in Illinois sometimes refer to tortious interference with contract claim as a claim for either 1. Tortious with contractual relationship, 2. Tortious interference with a contractual business relationship. Under Illinois law, the elements of the claim for tortious interference with business relationships, more commonly called tortious interference with prospective economic advantage, that are that 1. The plaintiff had a reasonable expectation of entering into or continuing a valid business relationship with a third party. 2. The defendant knew of the expectation. 3. The defendant initially and without justification interfered with that expectation. 4. The defendant's interference prevented the plaintiff's legitimate expectancy from ripening into a valid business relationship. Dowd and Dowd, Ltd. versus Glenson, 181 Ill 2D 460483-84, 1998. 5. The plaintiff suffered damages because of the interference. Voiles versus Sandia Morgue Corp. 196 Ill 2D 288 300-01, 2001. Courts and litigants in Illinois also refer to this claim as tortious interference with business expectancy. Queen Bee alleges that a full breach of contract must take place to have a cause of action. That notion and opinion could not be further from the truth. Queen Bee knew of this contract, and Queen Bee acts under the same terms as BHB in Queen Bee's relationship with Google/YouTube. Queen Bee initially and unjustifiably interfered with the contract agreement BHB has with Google/YouTube. Queen Bee intentionally and unjustifiably induced third parties to breach the contract by brigading and reporting BHB's channel without justification. There are many posts on X, formerly known as Twitter, from Queen Bee requesting YouTube to terminate BHB's account, even BHB did nothing wrong. This is directly inducing a party to the contract to breach said contract with no justification in doing so. It is an interference. Here, Queen Bee and her cohorts shut BHB's channel down for 3 months, substantially limiting BHB's ability to make money. This is a clear interference interference in a business relationship that damaged BHB. Prior to this incident, Queen Bee attempted to terminate BHB from the YouTube platform, used Queen Bee's audience to manipulate the algorithm intentionally, willfully, and maliciously, handicapping BHB's ability to grow and make money. Queen Bee made BHB spend more money and made it more difficult for BHB to ripen BHB's efforts. Queen Bee has publicly stated Queen Bee will terminate BHB from the YouTube platform and put action behind those threats. QB does not get to financially harm BHB, almost lose BHB's main account, and then say, oh well, BHB did not get terminated, so I am not responsible for any damages because I didn't succeed. It does not work that way. Queen Bee financially harmed BHB with the help of friends, subscribers, and other content creators. Queen Bee elicited help from and then say, well, that didn't work, no responsibility. This notion is preposterous. BHB's conduct with Google/YouTube provides BHB the opportunity to gain monetary reward through subscribers, members, super chats, super sticker, and super thanks. BHB's channel was manipulated through Queen Bee and those Queen Bee elicited help from, which caused damage, and Queen Bee's efforts that actually suspended BHB's account/channel for 3 months. BHB was not afforded any of those expected funds. If BHB is unable to produce content or the content is intentionally suppressed, it damages BHB. Queen Bee initially, without justification, interfered with BHB's business economic advantage and is responsible for damages that interference caused. BHB was required to open a new account and qualify the new account to be monetized just to get an income the months BHB main channel was down. BHB barely made it through those months after Queen Bee financially damaged BHB when Queen Bee and her team/audience manipulated the algorithm, suppressing content which causes damage. This is clear interference. That interference was intentional, deliberate, malicious, and without justification. That interference damaged BHB immensely. Queen Bee has hatred for BHB and is seeking to destroy BHB every way possible and will not leave BHB or BHB's channel alone despite not knowing BHB and filing this court action. Queen Bee is obsessed with destroying BHB and will not stop unless forced to do so by this court or have a judgment so large it will deter her from continuing this practice. BHB is not the only victim of Queen Bee. There are many that have been subjected to Queen Bee's ruthless practices online and offline. Illinois does not apply a heightened pleading standard to claims for tortious interference. A total breach of contract in not required. The mere interference in enough to maintain this cause of action, further making it more difficult for that business relationship to ripen, is also enough to maintain this cause of action. BHB has met her burden. BHB has a prima facie case related to this count which survives the motion to dismiss. Queen Bee insists on poisoning the mind of this court with repeatable statements of BHB which are irrelevant to these proceedings, and BHB did say and stands behind those statements. So what? It is irrelevant. Many people support BHB's words. Leilani Simons abused her child, Quentin Simon, from the time of birth to his date of his death at only 20 months old. Still irrelevant to this matter. Even if Queen Bee brings these statements as affirmative defenses, Queen Bee has no justification for turning up the heat to attempt to terminate BHB's YouTube channel and financially damage BHB. After that situation ended, which is what happened, and it persisted many months after, BHB returned to Florida. It still continues to this day, despite BHB being forced to be held captive by the constant surveillance of Queen Bee and her crew of misfits. Is Queen Bee really claiming affirmative defense for a statement made one day, and that statement was spoken in less than a minute on a day in October as her justification for 2 years of terror and malicious behavior towards BHB? If so, Queen Bee has just proven BHB's point. Queen Bee has no justification for these tortious actions against BHB. Moreover, those assertions are affirmative defense as opposed to an argument to dismiss this action for legal sufficiency. BHB contends that yes, many of Queen Bee's friends and other content creators Queen Bee elicits for help, as well as creators that were not elicited, have been critical of BHB, but other did not seek to destroy BHB or financially harm BHB. Queen Bee is the head of the snake. Queen Bee is the puppet master. Queen Bee would have been able to just speak about BHB and Queen Bee's disdain for BHB, but Queen Bee did not do just that. Queen Bee colluded with others to take BHB's channel out, a clear violation of law. Queen Bee interfered with BHB's contract, and that interference caused damages to BHB. Queen Bee's conduct went outside the bounds of First Amendment rights of speech when Queen Bee decided to attempt to take BHB's channel down and sought help from others to do that. Queen Bee is not protected by any law, remedy, or privilege. Queen Bee once again asserts Queen Bee is entitled to internet activism, which is a felony in the state of Illinois, and cautions the defense from going down this road for malpractice purposes. Illinois Criminal Code is very clear on this law. BHB would like to the courts to remember this admission, as it will be vital as we proceed to trial. Queen Bee has violated federal, Illinois, and Florida law civilly and criminally. BHB's only recourse is through a civil process to provide relief. 4. BHB has not pleaded specific, extreme, and outrageous behavior to support an intentional infliction of emotional distress claim. The tort of intentional infliction of emotional distress has 4 elements. 1. Extreme and outrageous conduct. 2. Intent by the defendant to cause or a reckless disregard of the probability of causing emotional distress. 3. Severe or extreme emotional distress suffered by the plaintiff. And 4. An actual and proximate causation of emotional distress by the defendant. Outrageous conduct. Tobias v. Winkler, 1987. 156 Ill App 3D 886 509 NE 2D 1050. The conduct must be extreme and outrageous. The liability clearly does not extend to mere insults, indignities, threats, annoyances, petty oppressions, or trivialities. It has not been enough that the defendant has acted with an intent that is tortious or even criminal, or that he intended to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Liability has been found only when the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Restatement, 2nd of Torts, Sec. 46, Comment D. 1965, Public Finance Corp. versus Davis, 1976. 66 Ill 2D 858990 NE 2D 765767. Courts may consider the frequency and duration of the defendant's conduct, particularly where a pattern of conduct exists. When deciding whether conduct is extreme and outrageous, we must first look at what constitutes extreme and outrageous conduct. Whether certain conduct can be characterized as extreme and outrageous so as to support a cause of action for the tort of intentional infliction of emotional distress necessarily depends on the fact of each case. Tobias, 156 Ill App 3D at 897 509 NE 2D at 1057. Here in this matter, defendants have made statements about the plaintiff and their conduct towards plaintiff is extremely extreme and outrageous that goes beyond the bounds of decency. There is overwhelming evidence attached hereto outlining a coordinated attack on plaintiff. Plaintiff reaffirms she does not know these individuals nor has had any contact with these individuals prior to the attack. 1. It is well established by statements made by defendant was willful, intentional, and with malice to cause substantial harm to plaintiff. 2. In an effort to remove her from YouTube by harassment, intimidation, mocking, colluding, and conspiring with others to inflict the maximum amount of distress on plaintiff, this has caused a great deal of distress to the plaintiff. 3. Due to the conduct of the defendants, an actual and approximate causation of emotional distress by the defendants, outrageous conduct has damaged plaintiff emotionally, mentally, and spiritually. The actions of the defendants have caused plaintiff to not want to work, making doing the job and wanting to broadcast next to impossible. The defendants have stated the plaintiff lied about being causing many to send emails and write posts about this, even to degrade our victim. Defendants further state plaintiff lied about the SA and the fact plaintiff's case hasn't been solved in an effort to grift. The definition of grift is petty swindling of an unsuspecting person, which is also claiming a crime BHB allegedly commits from unsuspecting subscribers that help support my viewer-sponsored channel. This made plaintiff physically sick, throwing up, crying, and not wanting to leave the bed. It took a lot for plaintiff to speak about this sensitive event to her audience just to be berated by the defendant's audience the next day. 4. No one should have to endure this conduct for simply covering cases of true crime. This is an assault in an effort to force plaintiff off YouTube so defendants can capitalize on the YouTube platform only with her select group of friends at the rest of the community's expense. This conduct is extreme and outrageous. Queen Bee cites BHB has not pleaded specific and extreme and outrageous behavior. Determination of extreme and outrageous behavior can only be determined by the jury on a case-by-case basis. Queen Bee's affirmative defenses, couched as a motion to dismiss related to legal sufficiency, does not survive the standard for a motion to dismiss because it is an evidentiary finding which cannot be had through a motion to dismiss for legal sufficiency. Queen Bee once again asserts and admits to committing a felony. As Queen Bee clearly stated, harassment is a criminal act and so is cyberstalking. BHB then goes on to add the legal definition for cyberstalking. Here we have another page of a case law for cyberstalking and harassment. BHB has properly stated and maintained Queen Bee's unlawful and criminal behavior that has led to BHB's proper cause of action for initial infliction of emotional distress. Queen Bee has acknowledged openly in these proceedings that Queen Bee is entitled to relief because this is just internet activism. Well, what Queen Bee has admitted to are criminal acts, not just tortious acts. BHB is entitled to relief. Queen Bee weaponized her audience with insightful language and then encouraged them to damage BHB and keep BHB under constant fear, which has negatively affected BHB as outlined in the SAC. But for Queen Bee, BHB would not have had to endure the level of harassment. It is much different to have a few content creators harassing one person, but to have over 1,200 sent by Queen Bee is over and above outrageous, egregious, and goes outside the bounds of normal decency. Queen Bee further states, and BHB has failed to plead facts as opposed to conclusions, that Queen Bee was intending to cause BHB severe emotional distress rather than simply have Queen Bee's content taken down. BHB has made multiple attempts to have Queen Bee take down the content, but Queen Bee told BHB, make her, and she will see BHB in court. No other diplomatic remedies have been successful, not even this court proceeding. Queen Bee is unwilling to change Queen Bee's business practices. BHB further sent several cease and desist letters, but those were unsuccessful. BHB has alleged Queen Bee willfully and maliciously undertook these actions specifically to damage BHB personally, professionally, and financially. Queen Bee stated publicly Queen Bee was doing this to make BHB lose her mind. This is pretty specific language and it cannot be disputed. Again, these affirmative defenses do not survive this motion to dismiss and are evidentiary findings as opposed to legal sufficiency challenges. Monetary damages, including but not limited to punitive damages, are at the discretion of this court and within the letter of the law. Moreover, not sufficient to survive a motion to dismiss related to the legal sufficiency of the complaint. 5. As to count 5, with no unlawful purpose or tortious or unlawful act pleaded, these is no civil conspiracy. Civil conspiracy involves two or more persons who combine for the purpose of accomplishing by their concerned action either a lawful purpose by unlawful means or an unlawful purpose by lawful means. Smith v. Eli Lilly and Co. 137 Ill 2D 222 1990. Vince v. Chandler 231 Ill App 3D 747 1992. In accordance with Illinois law, for BHB to plead and prove civil conspiracy and concert of action, BHB must demonstrate 1. A combination of two or more persons, 2. For the purpose of accomplishing either an unlawful purpose or a lawful purpose by unlawful means, 3. Concerted action, and 4. An overt, tortious, or unlawful act to further the plan. As alleged in the SAC, BHB claims the following: 1. Coordination between Queen Bee and others, which includes inciting Queen Bee's audience and eliciting help from other creators, or 2. The sole purpose of attacking, watching, monitoring, and to keep under surveillance online and offline, intimidate, harass, and cause disruption to Queen Bee and Queen Bee's YouTube channel, i.e. the individuals assisting Queen Bee at Queen Bee's request know about this plan and intend for it to be carried out. 3. The help Queen Bee elicited from others was a concerted effort to coordinate simultaneous defaming video that supports one another in Queen Bee's effort to remove BHB from the YouTube platform. And 4. Multiple people assisting Queen Bee at Queen Bee's request actually carries out some overt act that caused damage to BHB. An Illinois Appellate Court 1st District 5th Division found that the wife of an emergency consulting company employee who assisted her husband with the competing business was liable on a conspiracy claim. Under this decision, even if Queen Bee was acting on behalf of another, Queen Bee would still be held accountable for Queen Bee's part in said civil conspiracy. In this matter, BHB acknowledges BHB's contract with YouTube that governs compensation, among other things. This is the same contract and terms of service that governs Queen Bee as well. Queen Bee and BHB are also governed by YouTube's terms of service. These terms of service outline the do's and don'ts of YouTube. One of these terms of service governs creators' conduct known as harassment and cyberbullying policies. Under this directive, all individuals on the YouTube platform must follow and adhere to these policies to maintain their respective channels and or account, whether acting as an audience member, subscriber, or as a content creator. The very first paragraph says, we don't allow content that targets someone with prolonged insults or slurs. We don't allow other harmful behavior like threats or doxing. Under the demonetization and other penalties, it states. In some rare cases, we may remove content or issue other penalties when a creator repeatedly encourages abusive audience behavior, repeatedly targets, insults, and abuses an identifiable individual based on their intrinsic attributes across several uploads, exposes an individual to risk of physical harm based on the location, social, or political context, creates content that harms the YouTube community by persistently inciting hostility between creators for personal financial gain. Queen Bee has an independent duty under Queen Bee's contract with YouTube/Google and a duty of care to audience, subscriber members, and other creators, and Queen Bee has violated that independent duty and duty of care. The role of duty in civil conspiracy claims is at a crossroads. Relatively few courts have squarely addressed this critical issue. On one end of the spectrum, a developing line of case law in several jurisdictions imposes an independent duty requirement to restrain the spread of civil conspiracy liability to peripheral defendants. The leading case is from the California Supreme Court, which has held that liability for civil conspiracies is limited to those defendants that owed an independent duty to the specific plaintiff. On the other end is Delaware, which does not require an independent duty. Finally, some states, such as Illinois, inconsistently apply an independent duty rule. Queen Bee publicly elicited the help of others. Therefore, Queen Bee assumed responsibility for the actions of others who carried out those requests on Queen Bee's behalf. Court and legal scholars have historically struggled to find common ground in delineating a civil conspiracy claim. For instance, some courts view civil conspiracy as a derivative action that requires an underlying tort to maintain a claim, while other courts recognize it as a separate and independent tort. BHB contests that either way this court applies this standard, BHB has met this standard. Whether or not Queen Bee is required by this court to have an independent duty to BHB, one exists. Moreover, BHB contends whether or not this case of action needs to be tethered to another case of action, or if it can stand on its own merit. BHB meets this standard either way it is applied. At least one Illinois appellate court has reached the conclusion that there can be no civil conspiracy liability absent an independent duty owned by the defendant to the plaintiff. In Doe versus No, the 1st District 6th Division considered a civil conspiracy claim brought by a hospital patient against persons associated with their treating physician after the patient contracted HIV virus during surgeries performed by her doctor. She claimed that the doctor's partner and employer conspired not to reveal the surgeon's HIV status so as to gain consent to care and treatment that the plaintiff would otherwise decline. The court rejected this piling on of defendants, explaining that the duty to disclose risk to a patient rests exclusively with the doctor in a physician-patient relationship. No independent duty is imposed upon others. Therefore, BHB does not need to add additional parties to this lawsuit, as Queen Bee has alleged. YouTube is owned by Google. YouTube has special exemptions under Section 230. Section 230 is a section of Title 47 of the United States Code that was enacted as a part of the Communications Decency Act of 1996, which is Title V of the Telecommunications Act of 1996, and generally provides immunity for online computer services with respect to third-party content generated by its users. As such, Queen Bee is responsible for Queen Bee's own conduct and cannot redirect that liability onto YouTube, Google, or any other company, entity, organization that has protection provided under this U.S. code. Moreover, Illinois court also have steadfast rejected efforts to hold publishers liable to the general public for negligent publication of information that causes harm to a reader. Queen Bee has vicarious liability for harm caused by others. Queen Bee has elicited for help and or incited, such as her audience that does Queen Bee's bidding on Queen Bee's behalf. Even in the absence of specific and or direct instruction, Queen Bee created an environment that cultivated the actions BHB has had to endure, specifically over the last 12 months, as a direct result of QB's efforts, which had a boiling point in March of 2023, and then another intense round when this action was initiated July 2023 through September 2023. Vicarious liability or imputed liability is an indirect liability for the actions of another person, such as an employee's conduct falls under vicarious liability for the employer if it is the kind of which he or she is employed to perform is within the authorized limits of time and space and is performed for the purposes of serving the employer. BHB contends that BHB has no knowledge of whatever Queen Bee provides financial compensation to Queen Bee's daily panel guests, whether the content is either written or verbal, or if those panel guests are just daily volunteers. Queen Bee directs those individuals online and offline. For example, Queen Bee had a public conversation on Queen Bee's YouTube channel with a daily panel guest at that time time voices. Queen Bee is heard on multiple occasions and on several different dates and times of live stream broadcast, directing voices to send a binder to local law enforcement about BHB. When Queen Bee directed voices to send the defaming and malicious binder, Queen Bee assumed responsibility for voices' actions and the damage that action had on BHB. Queen Bee assumes responsibility for Queen Bee's audience. When Queen Bee directs Queen Bee's audience to assume a screen name of blank screen to flash mob BHB's channel and chat, Queen Bee assumes full responsibility for the resulting damages to BHB. Queen Bee incites Queen Bee's audience with language designed to elicit an emotional response from Queen Bee's audience, turning Queen Bee's audience into weapons. This is a calculated and strategic move designed by Queen Bee to avoid the responsibility for Queen Bee's actions. Queen Bee attempted to avoid Queen Bee's responsibility when Queen Bee elicited help from others and Queen Bee acquired that help. And when those requirements are carried out by Queen Bee's audience at Queen Bee's request, Queen Bee is ultimately responsible for the damages sustained by BHB financially, professionally, emotionally, and personally. Queen Bee assumes responsibility for Queen Bee's audience when Queen Bee directs Queen Bee's audience and or other creators to report BHB's channel to YouTube, also known as brigading. Queen Bee assumes and is responsible for the resulting damage to BHB. Queen Bee assumes responsibility when Queen Bee elicits help from others, either publicly and or privately, to harm BHB in a coordinated effort, and those efforts are carried out. Queen Bee assumes responsibility when Queen Bee cultivates an environment in Queen Bee's YouTube channel that any normal person would acknowledge would and or could damage another individual financially, professionally, and or personally. Queen Bee assumes responsibility when Queen Bee disseminates false and misleading information about BHB and others, then shares the same false information, creating a web-like effect for maximum damage to BHB in an orchestrated and concerted action to the detriment of BHB. Civil aiding and abetting is another type of vicarious liability that plaintiffs have attempted to apply in tort cases, as set forth in Restatement Second of Torts, Section 876B, for harm resulting to a third party from the tortious conduct of another. One is subject to liability if he knows that the other's conduct constitutes a break of duty and gives substantial assistance or encouragement to the other so to conduct himself. This theory, like the others discussed, has only been recognized in very limited context. Queen Bee directed, coordinated, conspired, and concocted actions in which Queen Bee assumed the responsibility of removing BHB from the YouTube platform with the assistance of others and at the express direction of Queen Bee. Therefore, Queen Bee is the responsible party in this action. Under Illinois law, pulling all the parties that Queen Bee conspired with are well over 15 different content creators and 1,200 plus subscribers. That is not necessary. There is no requirement to add those bad actors as defendants. Further, it does not prevent BHB from lawfully suing the others in their jurisdiction and are still fair game. Queen Bee's affirmative defense does not survive this motion to dismiss because, again, this is an evidentiary finding that cannot be had in a motion to dismiss for legal sufficiency. Count 6 must be dismissed because there is no well-pleaded claim. Queen Bee is unjustifiably retained benefit from BHB. BHB must prove each of the following 5 elements. 1, an enrichment. 2, an impoverishment. 3, a connection between the enrichment and the impoverishment. 4, the absence of justification for the enrichment and impoverishment. And 5, the absence of a remedy provided by law in order to establish and maintain a cause of action for unjust enrichment. As one might expect, some courts pay no mind to whether a claim for unjust enrichment is brought alone or with other causes of action. In Raintree Homes Inc. versus Village of Long Grove, for example, the Illinois Supreme Court noted that the plaintiffs have no substantive claim grounded in tort, contract, or statute. Therefore, the only substance basis for the claim is restitution to prevent unjust enrichment. Yet this fact did not doom the plaintiff's complaint. Unfortunately, though the Supreme Court did not analyze the issue, this position that unjust enrichment can be brought by itself makes some intuitive sense. It seems odd to make the availability of one cause of action contingent on the existence of some other cause of action, and if unjust enrichment simply requires that the defendant retain some benefit to the plaintiff's detriment that he ought not to be allowed to keep, then what does a second or third claim have to do with it? Queen Bee was unjustly enriched at the expense of and damage to BHB. Queen Bee has unjustly retained a benefit to BHB detriment, and Queen Bee's retention of the benefit violates the fundamental principles of justice, equity, and good conscience. It is unclear what the position of this court will render related to this cause of action and whether it has to be litigated independently or whether it will be litigated contingent upon another cause of action. BHB argues that no matter how this court applies that standard, BHB can and will establish proof of this count and cause of action, whether it stands alone on its own merit or whether it is contingent upon one of the other 5 preceding cause of action. In the 2011 case, Cleary versus Philip Morris Incorporated, the Seventh Circuit Court of Appeals squarely confronted the question of whether Illinois law recognizes an independent independent cause of action for unjust enrichment, or whether unjust enrichment must always be tied to another underlying claim found in tort, contract, or statute. The court reviewed 3 Illinois Supreme Court decisions and noted that the Illinois Supreme Court has articulated the elements of unjust enrichment without reference to a sporadic underlying claim in tort, contract, or statute. From these authorities, the court concluded the Illinois Supreme Court appears to recognize unjust enrichment as an independent cause of action. The court, however, could not avoid mentioning the Martis decision that suggests the opposite, namely that the unjust enrichment claim cannot stand untethered from an underlying claim. Suggesting one way to make sense of this apparently conflicting cases, the court focused on the disagreement over whether unjust enrichment requires wrongful conduct. Unjust enrichment is a common law theory and recovery or restitution that arises when the defendant is retaining a benefit to the plaintiff's detriment, and this retention is unjust. What makes the retention of the benefit unjust is often due to some improper conduct by the defendant, and usually this improper conduct will form the basis of another claim against the defendant in tort, contract, or statute. So if an unjust enrichment claim resists on the same improper conduct alleged in another claim, then the unjust enrichment claim will be tied to this related claim. And of course, unjust enrichment will stand or fall with the related claim. As outlined in the SAC, Queen Bee was not very popular prior to targeting BHB. Queen Bee's numbers were low and most likely not making much monetarily from the YouTube platform or either channel Queen Bee utilized and or operated. By attacking BHB in a variety of ways as outlined above, Queen Bee received an overwhelming amount of financial and or other monetary gains as a result of those malicious actions, and Queen Bee damaged BHB far more than financially or monetarily in order to reap that reward and benefit. Queen Bee profited off harassing, disparaging, defaming, stalking, monitoring, threatening, intimidating, and theft of BHB's content for over 20 months. Queen Bee unjustly enriched Queen Bee at the expense and detriment of BHB. As outlined in the SAC, Queen Bee allegedly aired BHB's content and received overwhelming financial and other monetary compensation, especially during October 2022 and December 2022. During the time, Queen Bee simultaneously aired multiple live streams that BHB broadcasted. Queen Bee received hundreds to thousands of dollars in super chats, super stickers, direct cash from cash-type apps, and other monetary benefits and rewards, all while diminishing BHB in the eyes of the public while stealing BHB's content for profit. BHB has alleged Queen Bee has intentionally and tortiously interfered with BHB's prospective economic advantage. Queen Bee willfully interfered, creating an unjust enrichment at the detriment of BHB. BHB has alleged this was willful, intentional, and for no good purpose than to harm BHB and BHB's business, among other torts and criminal behavior. BHB paid for all of the expenses of production, including but not limited to lodging, gas, equipment, food, travel, and a multitude of other things when Queen Bee sat home and just stole BHB's content and was financially rewarded for doing so. Nothing stopped Queen Bee from paying for Queen Bee's own costs of travel to produce her own content, but Queen Bee chose to steal BHB's. BHB is unable to raise copyright infringement in this court due to improper venue and jurisdiction, but BHB is not barred from raising it and exhibiting evidence for the cause of action of unjust enrichment. As outlined in the SAC, Queen Bee raised funds for this litigation by defaming BHB. This action would not have been brought if not for Queen Bee's actions. BHB went out of BHB's way to express to Queen Bee to leave BHB alone, but the attacks kept getting worse and worse. Finally, BHB had to take action. BHB declared publicly on BHB's YouTube channel if Queen Bee did not stop, BHB would take legal, and that legal action would cost Queen Bee thousands of dollars. Queen Bee doubled down on the attacks and used whatever audience members and content creators would help attack BHB and kept BHB under surveillance nonstop. BHB sent a cease and desist letter that Queen Bee ignored on 3 separate attempts by the United States Postal Service. Then BHB emailed the cease and desist letter, and Queen Bee went live expressing that Queen Bee just read Queen Bee's email and then proceeded to publicly attack BHB from Queen Bee's YouTube channel during a live stream broadcast. The more Queen Bee insults BHB, the more money rolls in. After BHB has enough and initiates legal action, Queen Bee publicly threatens BHB and then requests thousands in donations, resulting in Queen Bee being unjustly enriched for Queen Bee's malicious, willful behavior and conduct. Over the last 20 months, Queen Bee has profited off of BHB and to BHB's detriment. Queen Bee should not be able to retain that enrichment. Queen Bee has maliciously, willfully, intentionally, and with afterthought publicly attacked BHB. BHB was Queen Bee's content and primary source of revenue for the last 20 months, unjustly enriching Queen Bee at the expense and detriment of BHB. There is a direct link between Queen Bee's enrichment and the detriment of BHB. There was no legitimate justification for Queen Bee's tortious conduct and Queen Bee's lack of moral turpitude. However, the damage Queen Bee caused BHB needs to be rectified before this court. Queen Bee has received over $150,000 or more of unjust enrichment at the direct peril of BHB. Clearly, Queen Bee has received an unjust benefit while falsely claiming Queen Bee has not. 7. Having had a third try to plead as well as 2 roadmaps on how to properly plead and still failing, BHB's claim should be dismissed with prejudice. This notion that BHB is doing this for any other purpose than to seek justice against Queen Bee's bullying and criminal activities is preposterous. BHB has demonstrated merits. Queen Bee has not been damaged in any way, and American law is supreme here and does not entitle Queen Bee to any fees whatsoever. Furthermore, Queen Bee has not paid any money for this lawsuit and has no way of returning those funds to the donors and therefore benefiting unjustly. It's ridiculous to think BHB allegedly made a few statements about Queen Bee, a few liners according to Queen Bee, yet thousands of hours of content of BHB are just innocent construction. This court must denounce this nonsense. It has merits to all causes of action and should bar Queen Bee and Queen Bee's attorney from constantly raising frivolous lawsuit in these pleadings for no other purpose than for Queen Bee's YouTube channel content, and that for Queen Bee's right-hand man, Jane Doe, aka Burnt Toast. Queen Bee called for BHB to be arrested while recently in Tennessee and congratulated one unknown person on Queen Bee's live broadcast for doing so. BHB was stalked by a family that once again has communicated with Queen Bee, and BHB sent a cease and desist letter to counsel. But counsel to BHB, he is not Queen Bee's babysitter, leaving BHB vulnerable to bodily injury from the conduct of his client. And yes, BHB has every right to utilize the law and law enforcement to those ends. Queen Bee is creating issues as this action is being litigated, and it is creating more causes of action, not less. BHB has a right and a duty to protect herself and will absolutely start filing this with the local police, FBI, and be seeking a protective order if this persists. One such protective order resides within this proceeding as well. Queen Bee and her counsel are willfully and intentionally misleading this court as to what is transpiring behind the scenes, and this court must reject Queen Bee as this innocent victim of BHB. And tortious criminal she is that will not leave BHB alone due to Queen Bee's obsession with destroying BHB, including inciting Queen Bee's audience to attack BHB, keep BHB under surveillance, and continues and regularly tells Queen Bee's audience Queen Bee is about to start reviewing BHB again, which means starting Queen Bee's reign of terror upon BHB, her associates, and her family. BHB fears for her safety. Queen Bee would further like this court to believe this is mere criticism and BHB should just take it. BHB has watched many documentaries, TV shows, investigative reports, and other critical commentary, and BHB can't find one example that the criticism was almost every day for hours at a time for over a year. BHB really looked very hard and invested many hours of research on Google, calling resources, and so far BHB only found one other channel, documentary TV show, investigative report, or other critical commentary that invested this much time and energy as Queen Bee's channel. This particular alternative channel creator BHB located is a creator that Queen Bee has elicited help from, and still, as this action is before this court, elicits help from Jane Doe, aka Burnt Toast. At this point, I keep wondering who should be wearing a tin hat in this matter, because Queen Bee believes BHB defamed Queen Bee so much that Queen Bee's entitled to damages for alleging that BHB made 1 to 3 statements defaming Queen Bee, but the hundreds of hours of defaming commentary towards BHB are idle chit-chat and opinions merely taken out of context. It is a comical argument, to say the least. BHB has fully and in good faith complied with the order of this honorable court, making substantial modifications to the SAC. Apparently, Queen Bee believes BHB is required to prove BHB's entire case at the onset of this action versus alleging ultimate facts. What is the purpose of discovery but to flush out these allegations? The defendant's entire argument is discovery related. BHB is required to prove BHB's case by a preponderance of the evidence. The burden of proof is on BHB to prove BHB's case and the allegations therein. BHB has laid out a substantial prima facie case and supported all elements for each count, and has maintained in those pleadings the overwhelming supporting documentation BHB has in her possession, custody, and control. The defense has all but proven BHB's case in these pleadings. The defense lays out that the statements were made by Queen Bee, but were mere opinions, miswords, and or word salad. However, the roughly hundreds of hours of malicious, willful, and defaming commentary towards BHB BHB speaks volumes and is in Queen Bee's voice and on Queen Bee's own YouTube channel. Queen Bee further states that it is because BHB is a public figure and Queen Bee has the right to defame someone needlessly because of something that person did 10 months before. The only side throwing the proverbial spaghetti at the wall to see what sticks is the defendant, and all their admissions Queen Bee deems as affirmative defenses. Lastly, the most comical reason of all, BHB is just trying to cause financial harm to the defendant. Well, BHB was not the one attacking Queen Bee. BHB wasn't the one who coordinated with others to cause harm to Queen Bee personally, professionally, or financially, or to try to remove Queen Bee from the YouTube platform. BHB wasn't the one calling unknown people in an attempt to have Queen Bee arrested. BHB has done none of those actions against Queen Bee. Queen Bee committed those actions against BHB, and Queen Bee's defense is BHB did something Queen Bee doesn't like to someone Queen Bee doesn't even know either. It seems to BHB that Queen Bee is the one interjecting herself into situations Queen Bee is not involved in. It appears to plaintiff that defendant has brought this action on herself, and for the popularity of this lawsuit, it sure has been very profitable for Queen Bee at the detriment of BHB. Furthermore, Queen Bee hasn't spent a single dollar of her own money on this lawsuit, yet BHB has. So who's really trying to cost who money and time? However, BHB did on many occasions threaten Queen Bee with a lawsuit over and above what was provided for the court record. BHB stipulates for the record she indicated on multiple occasions the cost of such a lawsuit if the actions did not cease. BHB sent 4 separate cease and desist letter attempts. BHB has provided Queen Bee with an overwhelming opportunity to resolve the issue before the court intervention, but Queen Bee willfully and intentionally avoided service or ceased the action laid out in the amended complaint. BHB had no other choice but court intervention. Queen Bee can't now say BHB is just doing this for financial harm. If that were the case, why would BHB provide Queen Bee with so many opportunities to stop, cease defaming and malicious commentary and other actions laid out in the amended complaint that have caused personal, professional, and financial harm to BHB before bringing such an action? Doesn't make sense. While Queen Bee would love to allege BHB is a public figure, it does not make it so. There is no doubt BHB is actively working towards the famed entitlement. As unfortunate as it is, BHB has not, at this moment or any time in the past, been deemed and or classified as a public figure, and will not maintain that designation for the foreseeable future, in part due to Queen Bee's actions. Just because BHB is a journalist, activist, or associated with media does not deem BHB automatically a public figure, and many legal standards must be met. BHB meets none. Therefore, Queen Bee is not afforded the protections provided by this notion. BHB is a public figure. BHB is and has maintained throughout show commentary and within all pleadings herein that BHB is a private citizen. Conclusion: Queen Bee has done nothing but willfully, intentionally, thoughtfully, and maliciously mislead this court. Queen Bee has made statements knowingly false on their face. Queen Bee's counsel has created an even more toxic environment with his lack of adhering to his code of ethics, and have willfully put BHB in a situation, and that will create an event where BHB has and will in the future fear for her safety while performing her job functions. The courts must reject this notion BHB is doing this to Queen Bee to break her when she has raised over $70,000 and has not been held accountable for her unlawful behavior. Queen Bee has damaged BHB. Queen Bee keeps BHB under constant fear. Queen Bee is telling her audience she is going to continue doing what she has in the past to BHB, and there is no end in sight. BHB has merit, and this court nor Queen Bee can deny those facts. Queen Bee's conduct has led us to this point, not BHB's. Queen Bee and her counsel should be sanctioned for their continued and unprofessional behavior since the onset of this action. Wherefore, with the above stated, BHB requests this court to 1. Strike paragraph 88, 2. Dismiss count 2, harassment, 3. Deny defendant's motion to dismiss, 4. Defendant's answer due in 14 days. Respectfully submitted by Battery Betty, Upsetty Betty, Bullhorn Strangler, Bullhorn Betty, dated July 22nd, 2024. Certificate of service. Undersigned certifies and states that on July 22nd, 2024, plaintiff caused the foregoing document to be filed using the Odyssey e-filing system. The same plaintiff caused a copy of the same to be served as indicated below. Queen Bee's lawyer. I hope you have your popcorn ready, ladies and gentlemen. We are on to the best part of this filing. Betty has included the email correspondence between her and Queen Bee's lawyer, and oh boy, it's good. So let's get started.
Memo, Mr. Queen's attorney. It has come to my attention that your client is once again stealing my content and making daily videos about me again. She has reached out to yet another family and told them to call the cops on me, which they did, and we have it on videotaped. I have the people stalking me on my job and your client going to her platform for the law enforcement, which I have had it. Your client is a threat to me. She's a threat to people around me, and if this does not stop, I am going to go after sanctions. She is threatening my life. She keeps putting me in danger. Her and her friends keep coordinating against me on every single case I go to, and I am demanding it to be stopped, or I am going to fly in there and I am going to call every single emergency hearing I can possibly call, and I'm going to file every possible report with the police department. I have absolutely had it. She has put my life in danger her last time. If this does not stop, I am going to take major action. Immediately cease, and this is the last letter I'm going to send you to cease and stop assisting your client. I will start serving you as well because you are assisting her at this point. Sincerely, BHB.
MX, BHB. My representation of my client is limited to defending your frivolous suit against her and asserting her counterclaims. I am not her babysitter. Unless it has to directly concern the legal proceedings, I am not handling the same. Moreover, I do not work for you. I will be advising the court of your threats against me, seeming to assert I am an accomplice to whatever you claim you will take major actions on. Queen Bee's lawyer.
That's fine, Mr. Phillips. We know you're counseling her and we know you're giving her law and allowing her to do this to me, and you know what your conduct is disgraceful. It goes beyond the bail bounds of your lawful license. And you want me to amend my complaint? I will be adding all this stuff to it. You keep saying I have a frivolous suit. I will tell you this: if I get injured or because of your client, because you absolutely represent your client, and this is your problem too. I just want to say I don't want to hear you bitching because this is client. I am going to be filing everything I can as soon as I'm back to Florida. You are by far one of the most unethical people I've ever dealt with in the law before. Do you have a duty to control your client and you can't do it? I will start making sure that you're well abreast of everything that she is doing. I'll be sure to email you all of it so you can be a part of her crimes.
Okay, guys, that about covers everything from this filing. The only thing that I did not include was a 13-page article that Betty included at the end of the filing. I don't feel that it's important to add it here because this video is way long as it is. Thank you guys for being here, and I will see you next time. Bye.